Welcome again to this webinar, Parenting After Separation, with Legal Aid New South Wales and LawAccess. And I would like to begin by acknowledging that we are broadcasting from Aboriginal land, and for me it's the land of the Widjabul Waible people of the Bundjalung Nation, and pay my respects to elders past, present and emerging, and to any Torres Strait or Islander or Aboriginal people joining us today. And I would now like to introduce Michelle Tolmie from LawAccess, who will be presenting the webinar today. Welcome, Michelle.
Thank you, Bridget.
I'm just going to let you know what we will cover in the webinar today. Oops, sorry, just gone too quickly through that. So the topics that we're going to cover are making parenting arrangements, going to court, after court, child support, and then give you some information about resources and legal help for you or your clients. Okay, over to you, Michelle.
All right, thank you. So when parents separate, they often need to decide on the parenting arrangements for their child. This can include where their child will live, how much time their child will spend with each parent and other family members. This includes grandparents, aunts and uncles, how their child will communicate with each parent and those other family members, where their child will go to school, and who will have parental responsibility for their child. Now, parental responsibility refers to the powers and responsibilities that parents have to make major long-term decisions regarding the care, welfare, and development of their child. At separation, parents are presumed to have equal shared parental responsibility for their child. This means that both parents have a role in making decisions about the major long-term issues concerning their child. No parent is considered to be more important than the other. I've already mentioned some of these issues, such as where a child will live or go to school, but some further issues may include travel, both interstate and overseas, medical decisions, and religious and cultural upbringing. Parents share this responsibility regardless of what type of relationship they were in, whether they were married or de facto, or regardless of whether they were in a relationship at all. Parental responsibility does not cover the day-to-day decisions a parent makes when a child is in their care, such as what a child will wear and eat. Where parents have equal shared parental responsibility, this does not mean a child will spend equal amounts of time with each parent. Where a child lives and how much time they spend with each parent and other family members are separate issues to whether the parents share equal parental responsibility for their child. A child will spend equal time with both parents if the parents agree to this arrangement or a court finds that equal time is in the best interest of the child. All right, next slide, please. So negotiating a parenting arrangement. The law doesn't tell parents how to care for their child. Parents are responsible for deciding the parenting arrangements for their child between themselves. Every family is different and every child is different, so the arrangements that work for one family may not necessarily work for another family. Where parents can agree on the parenting arrangements for their child, they don't need to go to family dispute resolution, otherwise known as mediation, and they don't need to apply for court orders. Instead, they can make an informal agreement or a parenting plan. There are no rules for making an informal agreement. It can be written or verbal. It can be as detailed or as simple as the parents like and cover a short or long period of time. While an informal agreement doesn't have to be in writing, getting it in writing is always a good idea, as this helps to avoid misunderstandings and disputes about the terms of the agreement. A parenting plan is a written agreement that is voluntarily entered into by both parents that sets out the care arrangements for their child. There are no rules about how a parenting plan must be set out, but it must be signed and dated by both parents. Additionally, it must cover at least one of the following issues: parental responsibility, who the child lives with, who the child spends time with, communication between the child and their parents and other family members, financial support for the child, the process for resolving parenting disputes and changing the parenting plan, and any other aspect regarding the care, welfare, or development of the child. Both informal agreements and parenting plans are not legally enforceable. However, a court will take into account the agreement made in a parenting plan if a parent later commences court proceedings to deal with parenting issues. Where parents want an agreement that is legally enforceable, they can apply for consent orders. Consent orders are parenting arrangements agreed to by both parents that are approved by a court. They are legally enforceable, like orders made by a judge after a contested hearing. Applications for consent orders can be made to the Federal Circuit and Family Court of Australia or the local Court of New South Wales. Before parents make an agreement or apply for consent orders, they should get legal advice. It is best to check that the agreed orders are correct, they cover all the relevant issues, and will operate as desired before applying to a court. This is because there is no automatic right to vary court orders. If there is a problem with the orders, the parents will have to agree on how to fix the problem. If they can't, they may not be able to change the orders unless they can show that there has been a significant change of circumstances to justify a court changing the orders. It is especially important that parents get legal advice if there has been family violence or they have concerns for their own safety or the safety of their child. Where parents cannot agree on the parenting arrangements for their child, they must take genuine steps to resolve their parenting dispute before they can apply for parenting orders. They must attempt family dispute resolution, and they must write to the other parent to identify the issues that are still in dispute, make a genuine attempt at resolving the matter, and state the orders that they will ask the court to make if they have to apply for parenting orders. These steps are known as pre-action procedures. In limited circumstances, parents may be exempt from complying with these procedures if the matter is urgent. This includes situations where a child has not been returned, a parent has relocated or moved with a child without the other parent's agreement, or there is a risk that a child will be taken overseas and not returned. Other exemptions include where there has been or there is a risk of child abuse or family violence by a party, where a parent cannot participate effectively in dispute resolution, for example, because they are in jail. And finally, where a parent has breached a parenting order that was made within the last 12 months, and there are grounds to believe that that parent has shown a serious disregard for their obligations under the order. If a parent thinks they are exempt from attempting family dispute resolution, they need to speak with a mediation service or a lawyer. Where parents still can't decide on the parenting arrangements for their child, and they have followed the pre-action procedures that I've just outlined, they can then apply to the Federal Circuit and Family Court of Australia for parenting orders. This process has been designed to ensure that applying for parenting orders is an option of last resort. Okay, next slide, please. Right. When making parenting orders, a court will decide what is in the best interests of a child. What is in the best interests of a child is determined on a case-by-case basis according to the needs of each child. There are two primary considerations that a court must take into account when deciding what orders are in the best interests of a child. Firstly, the need to protect a child from physical or psychological harm caused by experiencing or witnessing abuse, neglect, or family violence. And secondly, the right of the child to have a meaningful relationship with both parents. When weighing up these two considerations, a court must give greater consideration to the need to protect a child from harm. The child's safety must always come first. In addition to the primary considerations, there are also additional things a court must take into account, including any views expressed by the child and any factors such as the child's age and level of understanding that the court thinks are relevant to the weight it should give to the child's views. the nature of the relationship of the child with each parent and other family members, how much each parent has participated in the child's life, including how much time they've spent with the child and how often they have communicated with the child, the extent to which each of the parents has fulfilled or failed to fulfill the parent's obligations to maintain the child, the practical difficulty and expense of a child spending time with and communicating with a parent, the capacity of each parent to provide for the needs of the child, including the child's emotional and intellectual needs, the willingness and ability of each parent to encourage a close and continuing relationship with the other parent. If the child is Aboriginal or Torres Strait Islander, the child's right to enjoy their culture and the likely impact that any proposed parenting order will have on that right, and whether the court should make an order that would be least likely to lead to further parenting proceedings. If a parent is unhappy with the orders made by the court, they may be able to appeal within 28 days of the date the orders were made. However, before they do this, it's important that they get urgent legal advice. This is because if their appeal is unsuccessful, it is likely the court will make a cost order against them. Okay, next
Michelle,
slide.
we just have a question, if you're happy to take it before we move on.
Yeah, sure.
The question is, the person would like to confirm that the time the children stay with each party is different with the parenting responsibility.
Correct. So parental responsibility is about making decisions regarding major long-term issues concerning a child. So where a child lives is one of those decisions, but it is a separate issue. And how much time a child spends with parents or other family members is also another decision, but it is again a separate issue. So really there are three key issues there.
Thanks, Michelle. I'll move on to the next slide.
Okay, so how do you go about changing a parenting agreement? Depends on what kinds of agreement you have. So with informal agreements and parenting plans, these can be changed at any time by the parents making a new agreement. If the parents can't reach an agreement, they must deal with their dispute in the usual way and follow the pre-action procedures that I've already outlined. They must take genuine steps to resolve their parenting dispute between themselves and attempt dispute resolution unless they are exempt. If the parents still can't reach an agreement after complying with the pre-action procedures, then they can apply to a court to resolve their dispute. All parenting orders can also be changed by agreement of both parties unless an order says otherwise. In some limited circumstances, an order might say that it can only be changed by a court. A court will only include this condition in an order in exceptional circumstances, including where it is necessary to protect a child from abuse, neglect, or family violence, or there is substantial evidence that one parent will likely use coercion or duress to force the other parent to agree to a parenting plan. If an order doesn't have this condition, it can be changed by an agreement made by the parents. Where the parents can agree on the changes, they can make a parenting plan or apply for consent orders. If the parents want an agreement that is flexible and they can change easily in the future, a parenting plan may be suitable. However, it will not be legally enforceable, and the orders that are replaced by the parenting plan will no longer be legally enforceable either. This means that if one of the parents decides to stop following the terms of the parenting plan, they can't be penalised. If parents want an agreement that is legally enforceable, they can apply for consent orders. If they can't agree on what changes to make, again, they must comply with the pre-action procedures. If, after complying with the pre-action procedures, they still can't agree on what changes to make, they may be able to apply to a court to resolve the dispute. However, they will have to show the court there has been a significant change of circumstances that makes a change necessary before the court will even consider their application. And if the court does hear their application, it will then decide whether to vary the orders. Okay, next slide.
We just have one more question, Michelle.
Okay.
Which one more affects the custody order? I think that's an old term though, isn't it?
Yeah, so custody is an old term, and it sort of refers to those three new ideas that I just discussed. So parental responsibility, where a child lives and who they spend time with. So all of the, I mean, what is the question again? Sorry.
Which one more affects who the child lives with? The term they've used is custody order.
Okay, so all agreements can deal with, or they should deal with, where a child is going to live and who they spend time with. No agreement deals with it more. They should all cover off that issue.
Okay, the person's just clarified. Is it the parenting agreement or the times they stay that has more influence, I suppose, on who has the major responsibility, who the child lives with most, I think is what the
Oh,
question is.
yeah, I think I understand. So normally in circumstances, you can have an agreement where a child lives with someone and they might spend time with another parent, say every second weekend. There can be agreements where children live with both parents. So it really does depend on what terms the parties have put into their arrangement, and also how much time a child will spend with both parents. If a child is living with one parent for a significant amount of time, then an agreement would generally reflect the fact that their child lives with that person and then spends time with the other parent.
Thanks, Michelle.
Okay, so I'll take you through a case study about changing parenting orders. So in this situation, we have separated parents Jason and Joanne and their 10-year-old son, Stephen. Jason and Joanne have parenting orders that were made 5 years ago. The orders state that both parties have equal shared parental responsibility for Stephen. Stephen lives with Joanne and spends time with Jason every week from Wednesday until Friday. Recently, Joanne has increased her working hours from part-time, 3 days per week, to full-time. Because of Joanne's new work commitments, the parties have been trialling a new parenting arrangement where Stephen lives with each parent a week at a time. Stephen has adjusted well to the changed living arrangements, and Jason wants to change the parenting orders to make these arrangements permanent. So how do the parties go about changing the orders? If the parties can agree to changing the orders, they don't have to go to dispute resolution or court. They can make a parenting plan, or they can apply for consent orders if they want it to be legally enforceable. If the parties make a parenting plan, they'll be able to change the agreement later on much more easily than if they apply for consent orders. And this gives them a greater level of flexibility in their parenting arrangements. However, the orders that are replaced by the parenting plan will no longer be legally enforceable, and the parenting plan will not be legally enforceable. So if one of the parties decides to stop following the parenting plan, they can't be penalised. If, as I mentioned, they want something enforceable, then they can apply for consent orders, and they will be enforceable, just like orders made by a judge after a contested hearing. However, they can be more difficult to change than a parenting plan if the parties can't reach an agreement between themselves. The court will make consent orders in this case if it decides that the orders are in the best interests of the child, Stephen. If the parties can't agree on whether or how to change the orders, they must comply with the pre-action procedures that I've already discussed. If they still can't reach an agreement, they'll be given a Section 60I certificate, which will allow them to apply for parenting orders. Before a court will consider their application, one of the parties will have to show there's been a significant change of circumstances which makes a change to the orders necessary before it will hear their application. Okay, next slide, please. Okay, so I'll take you through breaching a parenting plan. How you deal with a breach of a parenting agreement depends on what type of agreement was made. Neither informal agreements nor parenting plans are legally enforceable. So if a parent breaches this type of agreement, they must deal with their dispute in the usual way. They must take genuine steps to resolve their parenting dispute between themselves and follow the pre-action procedures. If they cannot resolve their dispute between themselves, they must attempt dispute resolution unless they are exempt. If the parents reach an agreement between themselves, they can make an informal agreement or parenting plan, or they can submit an application for consent orders to the court. And then if they still can't agree, they can apply to a court to resolve their dispute. Next slide, please. Okay. Where parents have parenting orders, they must comply with every order that affects them. This includes taking all reasonable steps to comply with an order. A parent will breach a parenting order if they intentionally fail to comply with the order. They make no reasonable attempt to comply with the order. They intentionally prevent another person who is bound by an order from complying with it, or they aid or abet a person who is bound by an order to breach it. If parents have a dispute regarding an alleged breach of their parenting orders, they must follow the process outlined earlier and attend family dispute resolution unless they are exempt. Dispute resolution offers the parties the opportunity to address any issues that may be causing the breach or any misunderstandings about how the orders operate. If there is an issue with the parenting orders, the parties may be able to make a new agreement to fix the orders, and this could involve the parties making a parenting plan or applying for consent orders. If a person believes they are exempt from attending dispute resolution, they do need to get urgent legal advice. If the parties cannot reach an agreement or they are exempt from attending dispute resolution, the parent alleging the breach may be able to make a contravention application to the Federal Circuit and Family Court of Australia. A parent can face serious consequences, including being penalised if they breach a parenting order without reasonable excuse. A court can order a parent to attend a post-separation parenting program, give the other parent make-up time, pay compensation to the other parent, enter into a bond, participate in community service, pay a fine, go to jail, pay the other parent's legal costs. If a parent is concerned about breaching a parenting order or thinks the other parent may have breached a parenting order, they need to get legal advice. And we'll go through a case study now about breaching a parenting order. So in this situation, we have separated parents, Johnny and Peggy, and their 7-year-old daughter, Matilda. Johnny and Peggy have parenting orders that were made 2 years ago. The orders state both parties have equal shared parental responsibility for Matilda. Matilda lives with Peggy and she spends time with Johnny every week from Wednesday until Friday. The parties followed the parenting orders without any issues for the first year after they were made. After the orders had been in place for about 1 year, both parties remarried. And since this time, there have been numerous disputes regarding the orders and parenting arrangements. Following their most recent dispute, Peggy spoke to Matilda about the time she spends with her dad. Peggy told Matilda that she didn't have to follow the orders if she didn't want to. On the following Wednesday, Peggy picked up Matilda from school. When Johnny arrived at the school and Matilda wasn't there, Peggy did not tell him she was going to collect Matilda. Johnny rang Peggy to find out where Matilda was. She told him that Matilda didn't want to see him this week. So I'll just run through the parties' legal obligations first, and then we'll cover the breach. So both Johnny and Peggy are legally bound by the parenting orders, and the orders apply to them, not to Matilda. They must comply with every order that affects them, and this includes the spend time with order that is in dispute. Under this order, Peggy must make sure that Matilda spends time with Johnny per the order, even if Matilda says she doesn't want to. To do this, she must make sure that Matilda is available to spend time with Johnny at the time stated in the order and positively encourage Matilda to spend time with him. Peggy must follow this order until Matilda turns 18 or the order is changed by new parenting agreement or order. So, covering the breach, Peggy breached this order by intentionally failing to comply with the order. She did so by refusing to make Matilda available to spend time with Johnny, not actively encouraging Matilda to spend time with him, and telling her that she didn't have to comply with the parenting order. As I mentioned, the orders apply to the parents, and it's the parents who are legally bound by them. A person breaches a spend time with order if they let their child decide whether they want to spend time with the other parent, or they tell their child they don't have to spend time with the other parent. In this case, Johnny may be able to file a contravention application to have Peggy penalised for breaching the order. Okay, we'll quickly run through child support. So child support is money paid by one parent to the other parent to help with the costs of the care of their child. And this is different to spousal maintenance. Both parents have a legal duty to provide financial support for their child. The duty exists regardless of what type of relationship the parents were in, if they were in one at all, where the child lives, how much time the child spends with each parent, if at all, and whether one or both parents have repartnered or remarried. There are different ways that parents can deal with child support. They can make an informal agreement between themselves where the parties negotiate privately and they collect child support privately. They can arrange for a child support assessment where the parties apply to Services Australia to undertake an assessment of the amount of child support that a parent should pay, and Services Australia can also collect this payment. And then parties can make a child support agreement. There are two different types of agreements that they can make, a binding or limited agreement. A binding child support agreement is a written agreement between parents about child support. It must be signed and dated by the parents. Parents must receive legal advice before they can enter into a binding child support agreement. A limited child support agreement is also a formal agreement about child support, but parents don't need to get legal advice before they enter into one. If parents apply for a child support assessment, they must notify Services Australia within 28 days of any changes to the parenting arrangements for their child. If they don't, the parent paying child support may pay too much, or they may not pay enough and build up a debt. The parent receiving child support may get paid late, not be paid enough, or also be paid too much and have a debt and have to pay money back. In addition to child support, a parent may be eligible for Centrelink payments, including pensions and allowances, family tax benefit, and childcare fee assistance. Okay, so here is a list of resources that you can use to assist your clients. I'll just note that some of these resources have not been updated since the creation of the Federal Circuit and Family Court of Australia. Some of them will still refer to the old courts, so the Federal Circuit Court and the Family Court. While they haven't been updated, they are still very useful. So I'll take you through them now. First up, we have Amica. This is an online tool that assists separated couples to reach an agreement on parenting matters, and it is an initiative of National Legal Aid. We have a guide to parenting orders on the Attorney General's Department website. We have the Best for Kids website, which is run by Legal Aid New South Wales, and it has resources for both kids and parents. We have the Federal Circuit and Family Court of Australia website, which has a detailed guide to parenting matters, and it includes links to the relevant brochures, forms, and fee information, and it is under the heading Children. And then we have a series of Legal Aid New South Wales brochures. So I'll just note that this is not a complete list of Legal Aid's parenting brochures. At present, a number of the brochures are being updated following the creation of the Federal Circuit and Family Court of Australia. Once they're updated, these brochures will be made available on the Legal Aid website. And then we also have the Services Australia website, which has a detailed guide to child support. In terms of getting help for your clients, there are a number of services that people can access. So they can come through LawAccess, and we've got the phone number there. So we can provide information and some limited advice over the telephone in regards to parenting matters. There is also Legal Aid who can help. So there's the in-house family lawyers. There is the early intervention unit, the domestic violence unit, and then the child support service. There are some community legal centres in New South Wales, including the Women's Legal Service, that assist with parenting matters. And these are similar to Legal Aid in the sense that they're there to help people with low income. And then people can also access assistance through a private lawyer. And there is the Law Society of New South Wales solicitor referral service for anyone who would like a referral to a private lawyer.
Thanks, Michelle. We have another question, if it's a good time to read it out to you now. If a parent is told by a child that they are experiencing corporal and unusual punishments, and the example given is being locked in a cupboard by the other parent, but there is no evidence apart from that child's disclosure, How
Yes.
should the concerned parent respond? And there's a follow-up question, would it be ethical, even if it is illegal, to breach an order in those circumstances?
Okay, so ideally, when there are parenting orders in place, you would try and avoid breaching them wherever possible. There is a possibility, if you can establish that you have a reasonable excuse for doing so, to avoid being penalised by a court. Normally, if there are those kinds of issues, you would try and raise them with the other parent if it's safe to do so. If it is unsafe to raise those issues and have the discussion about any kind of treatment about of the child, or you think it's unsafe for a child to go and spend time with the other parent, it's really important to get legal advice, because, as I say, you can be penalised if you are breaching a parenting order. So it may be a case that if there's a dispute, parties would have to try and attempt family dispute resolution if it's safe and appropriate to do so. If there are other issues in terms of the child's safety, it may not be appropriate in limited circumstances, to continue following those orders. But if that's the case, generally, you would be looking to try and change the orders if that's necessary. If you're intending not to comply with them anymore, then you would be wanting to change them, essentially.
Thanks, Michelle. And there's just another audience member has asked if you wouldn't mind going over again the penalties for breach of a parenting order.
Sure. So there's several. So it's not, I don't know if you consider it a penalty, but a parent can be ordered to provide the other parent with makeup time. For example, where a child has been withheld and not been made available per the orders. A parent can also be ordered to attend a post-separation parenting program, and this is usually done through your local family relationship centre. So I know some names are Parenting After Separation is often a common one. So there different centres have their own names for it, but they all run those different programs. They can be ordered to pay compensation to the other parent, enter into a bond. They might be ordered to participate in community service or pay a fine, and worst case scenario, you can actually go to jail for up to a year. That is a penalty that's reserved for the most serious breaches, but it is something that's available. And I guess also there's the risk of cost order being made against a parent who has breached orders.
So what would be the most serious breach that might result in a period of imprisonment?
So you're looking at a situation where a parent is just refusing to comply with the orders under any circumstances. They're just not making the child available. You might have issues where, they are discussing things with the children that's not appropriate. They might be trying to put some ideas into a child's head about the other parent to try and affect that relationship. It is for really serious situations, but there are some limited circumstances where they do occur.
Thanks, Michelle. Okay, we'll just let everybody know that the next webinar in this series is going to be held in May, and the topic for that webinar is separation, divorce, and property. Seems like there's a lot included in this next one. So we're scheduling that for the 25th of May at 10 a.m. And if you receive our Law for Community Worker e-alerts, then you can look out for that one being advertised in the alerts so that you can get the link to register. So yeah, that's the next one in this series scheduled for May. And we'll just give people time to ask any other questions that they might have before we finish up today's webinar. Also, to let people know, the links that are included in the slides that you've seen today will be included in the email that you receive an hour after this webinar finishes. And I will send a copy of the presentation to you in an email as well following the webinar, so that you can have a look through the slides just as a reminder. And as well, of course, this webinar, like other legal aid webinars, is being recorded. So if you'd like to come back to it, you can do that. It'll go up in the next 24 hours, and you can view this webinar and other webinars that have been recorded by Legal Aid through Legal Aid's YouTube channel. The next question we received is, what is the threshold income for a legal aid grant for court representation? So there isn't I'm not aware specifically that there is what the level of income is. Do you know, Michelle, off the
No,
top
I
of your
don't.
head?
I
I
don't
think,
know.
I mean, there is definitely a threshold for income and assets. So any eligibility for a grant of legal aid is subject to a means test and a merit test. I would suggest that you have a look on Legal Aid's website, because I'm pretty sure that there is a calculator that you can put your information into to get an idea about whether you may be eligible or not. But the other thing that I would suggest is to, if you are hoping to get legal aid representation, is you can make an application for a grant. Probably a good idea to get some advice from a solicitor first, and then they can assist you with how to go about making an application for the grant, and then you'll find out. Once we've registered the webinar, I can send the link to you. Does Legal Aid offer grants for property disputes? Are you
In some
aware of that,
limited
Michelle?
circumstances, so there, I guess that sort of covers two issues. So there is the Commonwealth property mediation pilot that's been run through Legal Aid at the moment, where parties can get potentially a grant of aid to go to mediation to try and resolve their dispute. That would be separate to a grant of aid to commence proceedings. There would be, I guess, limited grants available in that respect, but there's definitely the Commonwealth mediation pilot, and there's some information about that, including the eligibility criteria on the Legal Aid website. Applications for both of those are also means and merits tested. So again, you can use that means calculator to determine whether you're eligible.
And we have another couple of questions. The next question is, with less flexible parenting orders, how do they account for change as children grow from pre-adolescent to adolescent with differing best interest needs, including greater autonomy and self-determination?
Yeah, so the court will determine what is in the best interests of each individual child, not a group of children or siblings. So if orders are made when a child is very young, it would have to include provision potentially for that time and parenting arrangements to change as that child gets older and they're able to cope with more time away from their primary caregiver. And that can all be written out in the orders. And if necessary, if the parties want to reach an agreement between themselves, they can then change their parenting arrangements. Or if there's an issue and they can show a significant change of circumstances, then they may be able to vary them by making a sole application as well.
I guess, Michelle, just it would also depend on whether there were parenting orders by agreement or whether they were court ordered, as to how flexible it would be to make changes as the child grows.
Yeah, so if there are orders in place, whether they're consent orders or parenting orders, they're both legally enforceable, and the process to change them would be the same. If it's a parenting plan, those are not court ordered, so the parents can change them at any time by agreement. So they just need to reach a new agreement. And the same with parenting orders. It's just a question of whether or not the parties can reach an agreement, or if they can't, then they need to follow the pre-action procedures to try and resolve their dispute before they can apply to a court.
Okay. Another question is, can a parent take a child overseas, for example, to visit the child's grandparents without notice, would this be regarded as a breach?
If there are orders in place, it potentially could be a breach. So ideally, if you're going to take a child overseas, you would always want to have agreement with the other parent. If there are any issues in respect of a child being taken overseas, if necessary, you can apply to a court for orders that would allow that to happen, or that would set up the parameters for how that travel is to occur. But it's always best to get that agreement with the other parent, and it may be essential if there's parenting orders in place so that the parent's not in breach.
Another question is, are there any issues with one parent choosing a preschool appropriate for their children whilst in the process of parenting order applications? The other party appears to dispute all suggestions. I guess that's one parent
Yeah,
trying to move forward with arrangements for the child whilst they're in the midst of that process.
yeah, correct. So yeah, you can enroll your child. Ideally, parties would try and resolve that dispute between themselves or go to mediation if they need help. Um, if a child has already been enrolled, and there's no orders in place saying that they can't attend that school, or the parties must agree, I guess there's no legal obligations on you, or you're not in breach of any orders by sending your child without the agreement of the other parent. But ideally you would try and reach that agreement between yourselves if possible. It may be, if you're going through the parenting proceedings, that you'd have to cover those issues in orders, not just in respect, I guess, of childcare, but longer term schooling issues. Yeah.
Okay, it looks like that might be all the questions that we have this morning. Some people have commented that hang on, sorry, a couple more have just come through. How are the child's human rights and express wishes for their own living arrangements taken into account by the court?
Yeah, so a court will take a child's views into account. As I mentioned, what weight a court will give to a child's views will depend on their age, the level of understanding, and any other relevant factors, that may affect what the court thinks the weight it should give to that child's views. A court won't consider a matter purely based on what the child's views are. It will consider all of the relevant factors that it must take into account to determine what is in the best interest of the child. But the child's views certainly are something that the court will take into account. And I guess as children get older, those views can be given more weight. With the younger children, they may not be given as much weight.
Thank you, Michelle. I'll just give everyone a couple more minutes to see if there are any other last questions before we finish off. We're still within the hour, but I think the information's been very clear, so it probably hasn't prompted too many questions this morning. Okay, so if you do have any questions that arise after today's webinar, feel free to send them to us at the email address on the screen now. That's celie@legalAid.newsouthwales.gov.au. And for anyone that had trouble with having a clear line this morning, this webinar is being recorded and you can come back to it and listen again through Legal Aid New South Wales YouTube channel. And as we said, then there'll be the next webinar on the 25th of May at 10 a.m. and the alert will go out soon with the link to register for that webinar. If you don't already receive the alert, I've included a link to register to subscribe to the alerts so that you can receive those in your inbox and be aware of other webinars in this series and other webinars that Legal Aid is holding. All right, so we'll leave it there then for this morning. Thanks everybody for attending today and listening, and thank you, Michelle, for sharing your expertise in this area.
Thank